knowledge. And we were getting a lot of requests that on YouTube, we can find all sessions on different aspects of law. But there is one service law aspect which you normally don't find. You find one particular session, etc. But be that as it may, we had requested Mr. P.S. Rajagopal and Trivikram and his associates were kind enough to connect with Mr. P.S. Rajagopal at one point of time. Therefore, in this legal journey, we have connected together to take a series. Approximately, it will be more than 10 sessions. And those who are connected with us or those who have missed it can always connect with us to have the latest updates of service law aspects, more so, and other issues which we'll be taking on the Beyond Law CLC. And those who have missed the earlier sessions of Mr. P.S. Rajagopal, or for that matter, all other speakers, can like, subscribe, and share to that channel of Beyond Law CLC to understand how the legal journey by Beyond Law CLC to decimate knowledge not only on law and beyond that, different soft skills have also been explained. One issue, since we are taking the series in a chronological manner, we thought why not take a particular session in this way so that we can understand right from the basics how the service law is introduced. Therefore, the sources of service law is the topic for today, wherein we discuss Act, rules, executive instructions, circulars, and office orders. The meticulousness of Mr. P.S. Rajagopal can understand that we had placed all these words in a different pattern. He said, no, this is not the way. It has to be put in a chronological manner. You can have alphabets, but to make it a word and a sentence and then paragraph, and then what they say, the story and the journey of service law, it has to be in a chronology. In a short 1 minute, he told me that what is the relevance of drafting for any particular aspect, be that as it may, even of a flyer. Without taking much time, we will ask Trivikram, who is a knowledge partner with us today, to, in the end of the session, to say issues. Since people are waiting to have the trigger of, as they say, the launching pad for the service law series. And we are always indebted and will continue to remain indebted to Mr. P.S. Rajagopal, who always shares his knowledge, be that as it may, even on the latest judgment, if we say by Monday, sir, we want a session on Friday, Wednesday. He has been kind enough. So akin to his name, he's King of Hearts and continues to share his knowledge. Over to you, sir.
Mr. Vikas, Trivikram, and colleagues in the profession, and those of you who are not advocates who have joined this session. When Vikas requested me that I have to do a series on service law, first I was perplexed because most of us know, and most of you know, service law is mostly lawyer-made law, I would say, and then judge-made law, because lawyers would have argued and judges would have, if it has appealed to them, they would have incorporated these judgments. But then I found though lawyers have been largely responsible for development of service law, basics of this are elsewhere. Therefore, I said we start with sources of service law. Now, to why I am starting with this session. There are different sources, like, of course, source for all laws in the country is the Constitution. Then within the Constitution, or within the framework of the Constitution, various other enactments are made by the legislature. Within the delegated powers by the legislative enactment, statutory rules are made. And then comes executive instructions, office orders, circulars, office memoranda. A plethora of sources are there. Therefore, the hierarchy of these sources, which would prevail over the other, is most important. Therefore, I thought we will start from sources of service law. Then we will go into the individual aspects or the particular subjects within the broad canvas of service law. Before we go into the question as to the sources of service law, I would like to broadly place before you the three different branches of or three different shades of employment we see in the country. First, of course, going by size, the largest is employment under private sector. Then comes employment under public sector corporations, government controlled bodies which are not statutory, and then I would say services under the government. Now, about 25 years ago, if you had asked me, classify the employments, I would have first rated government service, then I would have come to the public sector employment, and then, of course, the other bodies. Now, though the government is huge, governmental organizations are huge, the employment under the government is dwindling. Governmental sector also is dwindling. And simultaneously, there is a growth in the employment under the private sector. Therefore, I have changed the order based on numerical strength. A few words I should say at this stage about employment under private sector. Because though it is the largest employment provider, there is not much of service law insofar as employment under non-state sector is concerned. Those employments are governed by straight and simple contract act. If it was pure and simple contract act also, it would have been tolerable for the workforce. But there is one important hindrance when it comes to service law under a private employer. That is non-enforceability of contract of personal service. Now, under the Specific Performance Act, the Specific Relief Act, contracts of personal service are not specifically enforceable. No court can grant a degree of specific performance or of contract of employment. Therefore, if an employee is wrongfully terminated, it cannot best be treated as breach of contract. And what the employee or ex-employee would be entitled to will only be damages. Therefore, the services under the private employer cannot strictly sensu be said to be covered by service law. It is covered by contract law or law of contracts, in which the enforceability of contract of personal service is also virtually negated by Section 14 of the Specific Relief Act. But one exception which may give rise to a larger quantum of damages is that even in private sector, an unconscionable contract which is opposed to public policy as laid down by Section 23 of the Contract Act, that would not be countenanced even in private employment. This difference between contract of service, this emphasis on unconscionable terms in contract, even in private employment under the Contract Act, has been highlighted by Justice Madan in a case arising from termination of a public sector employee, not in This has not come in any private sector employment case. And subsequently, the law laid down in Central Inland Water Transport Corporation Limited versus Brajanath Ganguly, that has been extended to commercial contracts also, where the courts have perceived that the bargaining power between the two parties is unequal. This has nothing to do with our main discourse on service law, but I thought it is necessary to emphasize the difference, because as practicing advocates, we come across many times, particularly from the software sector, and then where it is totally unorganized, because they think that if I get organized, organizational strength will weaken my career progression. That instinct of selfishness is more in the so-called white-collar or gold-collared employees. It is not that much in blue-collared employees, but economic reality in the country is that slowly they are also losing in organization. Therefore, as advocate, you will be facing daily, sir, I have been dismissed from service. I have been asked to resign. This is the most common feature of easing out an employee in private sector these days. They will call the employee, ask him to sit in a virtual gas chamber, like what I can say, a torture chamber, and until they sign on their resignation letter, they would not be allowed to go out. It is virtually confining an employee and extracting a resignation letter from all those cases are coming to the advocates. The first thing we have to tell is, look, you cannot go to High Court. You will have to go to the civil court. Even if you go to civil court, you cannot get re-employment in the same employer. All that you can get is damages. If you are willing to fight for that, you can. That is about contract-based service law. Now coming to government and governmental sector. Here we have very, very varied sources of law. First, of course, is the Constitution of India, then the enactments, then the regulations in that order. Now, what are the constitutional provisions insofar as service under the state is concerned? When I say services under the state is used in an expanded, larger meaning than either state government or the union government. There are two distinct parts dealing with services under the state within the Constitution. First is Part 3. Part 3 deals with fundamental rights. Then is Part 14. Part 14 deals with employment under the state and union governments, and are the order used there under the union government and the state government. Part 3 and Part 14 of the Constitution govern the entire source of fundamental law or basic law or ultimate law, whatever name you can give. It is the fountainhead of all laws. Any law contrary to or any rule contrary to Part 3 of the Constitution in respect of public employment, that is under the governmental sector, but not stricto sensu within the government. The Part 3 of the Constitution is the source of strength in law for the non-state government and non-central government employees. And when it comes to government employees, Part 14 is an added safety net against exploitation and victimization. About 50-60 years ago, victimization was a word which was more found in labor law than in service law. But today, in the service law, we come across more and more cases of victimization. Therefore, victimization is something that is safeguarded against in both in Part 3 and Part 14. Why I say Constitution is the basic law is, it is the source of all laws. That is number one. Second, Article 13, Article 12, Article 13, both of which are part of the Part 3 of the Constitution. They are very, very significant insofar as service jurisprudence is concerned. Article 12 defines state. What is state? By Article 12, state in this part of the Constitution is relatable to, or insofar as Part 3 of the Constitution is concerned, it includes, and there the definition is inclusive. Kindly note that it is inclusive definition. And what it says is, in this part of the Constitution, in this part, unless the context otherwise requires, state includes, kindly note the word includes, the Parliament of India, the government and the legislature of each of the states, and all local or other authorities within the territory of India or under the control of the government of India. One is local authority is automatically a state. Then any body, though it is not a local body, it may be a business organization like Airport Authority of India, or it may be a commercial organization like Oil and Natural Gas Corporation, Industrial Finance Corporation, or Nationalized Bank, or even Central Inland Water Transport Corporation, or State Road Transport Corporation. All these statutory bodies at once come under the net of Article 12. Then there are certain bodies which are not statutory bodies, like say Institute of Public this. There are the Indian Institute of Science in Bangalore, which is not a statutory body. It is a society registered as Societies Registration Act. Or about Postgraduate Institute of Medical Sciences, Chandigarh. I do not know whether it is a statutory body. To my knowledge, it is also a, first it was started as a society. Now I don't know with the corporatization, whether it has been now registered as a company or something like that. But it started as a society. Then All India Institute of Medical Sciences, it also started as a society. Now there is, of course, AIMS Act also. All these bodies, though technically they are autonomous societies registered under the respective state enactments dealing with societies registration, every one of them become a state if state is having overall control over the affairs of those bodies. All such bodies fall within the scope of Article 12. Once a body becomes the state as defined under Article 12, then our first source of law is Article 14, which guarantees equality before law. Article 16, which guarantees equality in the matter of public employment. Article 19, which guarantees 6 freedoms to the citizens. Then Article 21, which protects right to life and liberty. Article 23, which is injunction against exploitation. Then part 4 also, because though Article 12 in its definition of the state does not include part 4 of the Constitution, Supreme Court by interpretation has said, though directive principles of state policy are not independently enforceable, they can be enforced as part of part 3. Therefore, though Article 12 by definition does not include these bodies as state for the purpose of part 4, by virtue of interlinkage between the fundamental rights and directive principles of state policy. What are the directive principles of state policy? Equal pay for equal work, Article 39D. Then rule against exploitation, providing humane working environment, or for that matter, the statutory right under Prohibition of Sexual Harassment at Workplace Act. All these things are relatable to part 4 and they can be enforced as part of part 3. The distinction between services under the state and the state sector then boils down to applicability of part 14. Part 14, there is see at the craftsmanship of the Constitution, look at Article 12 coming under part 3 defines state, the word state, inclusively. The intention of Constituent Assembly is that enlarge the scope of state so that larger segment of the workforce will get protection of non-discrimination, non-arbitrariness, equality. But when it comes to part 14, the state is defined as the states included in Schedule 1 to the Constitution, excluding Jammu and Kashmir. Now I don't know, Jammu and Kashmir is excluded then also, now also, but as 3 different territories. Therefore, by definition, part 14 is not applicable to anybody except the government employees of the state and the center, and restricted to those territories which are scheduled in Schedule 1. There are certain very special provisions of protection are there. First is Article 309. That is service condition should be governed. The president or the governor, they can make the rule in the absence of a legislation. And if legislation enters, they cease to have power. Most important protection under Article 311, under Chapter 14, Part 14 comes under Article 311. That is, no civil servant shall be dismissed, removed, or reduced in rank, except after holding an inquiry in accordance with principles of natural justice. Natural justice is not a phrase used in the Article 311, but the seeds of the natural justice is found in Part 14. Part 14 says the inquiry has to be held, giving a reasonable opportunity to the government servant. That reasonable opportunity has been expanded, new dimensions have been added, and innovative concepts have been built into that reasonable opportunity by advocate-made and judge-made laws. Basic law remains what is made by the Constituent Assembly. That is reasonable opportunity. Another aspect of Article 311 is that the reduction in rank or removal or dismissal of a government servant can occur only at the hands of appointing authority. This is a function not delegatable to anybody else by the appointing authority. Of course, there are various service rules which say that he can be dismissed either by appointing authority or by an authority to whom it is subordinate. This dismissal, discharge, and reduction in rank only at the hands of the appointing authority is something that is not available under part 3. Thanks to Justice Chinnam Reddy, he said in UP State Warehousing Corporation Limited versus Vijay Narayan Vajpayee, where he said, I find it indeed hard to find out any difference between an employee of a statutory body like UP Warehousing Corporation Limited and employee of a government. Therefore, I can extend the principles underlying Part 14 by resort to Article 14, 15, and 16 to public sector employees also. That is the starting point of development of service law insofar as public sector is concerned. Earlier to that, it has been said in Sukhdev Singh, where the question of the employees of ONGC, IFCI, and one more organization came up for consideration. But succinctly, it was Justice Chinnam Reddy who stated in Vijay Narayan Vajpayee's case that there is no distinction between a public sector employee and a government employee insofar as constitutional values are concerned. Then comes the rules made by the statutory body or by the legislature or by the government in exercise of its statutory powers. In different states, different mechanisms have been evolved to lay down the conditions of service of government employees. Until about 3 decades ago, it was governed by the rules made by the president or the governor under proviso to Article 309. Then the legislature took over. The states made the State Civil Services Act, whereby governor was denuded of the power to make service rules, and it was left to the executive to make rules under the state enactments. But that is not a major change, because whether it is governor or government or president or government, it hardly matters. As Justice Krishna Iyer said in famous Maruram's case, which dealt with power of pardon, he said, governor is shorthand form of the government. Therefore, governor cannot act except on the advice of the cabinet. Therefore, governor and government, it doesn't make much of a difference. On that, we need not bother too much. Then, in the absence of statutory rule, or a rule made under Article 309, or a rule made by the legislature, we have the rules called government orders issued under Article 162 in respect of state government employees, and Government orders issued under Article 73 in respect of the central government employees. These are issued either in the name of the governor or in the name of the president, but by the executive government, depending upon whether it is state or whether it is central. But nonetheless, they are called executive instructions or administrative instructions. Then we have this a strange type of source of law, circulars. At one point of time, circulars were held to be unenforceable. At one point of time, circulars were berated by the courts, saying that they are interdepartmental communications. Then the things slowly changed. For the first time in KP Joseph, Supreme Court said, office memoranda are not statutory rules. They are generally not enforceable. But if it gives a right to an employee or casts an obligation on the employer, then the rights and obligations created by that OM are enforceable, subject to one condition, that is, it shall not be contrary to any superior law. Then the very interesting question came for the first time before the Supreme Court in Gundachar's case, which went from the then Mysore High Court. The question was whether Mysore State Road Transport Corporation, a corporation established under Road Transport Corporations Act 1951, whether it can make appointments in the absence of regulations made under Section 45 of the Road Transport Corporation Act. Of course, similar question had arisen in the governmental service in B.N. Nagarajan, first time. Again a case which went from the state of Mysore. We have given a lot of contribution. We have made a lot of contributions to this law. In B.N. Nagarajan, while dealing with the state services under the state, Supreme Court said, in the absence of rules made under Article 309, orders can be issued under Article 162 by way of executive instructions, laying down recruitment rule, pay scale, everything pertaining to service conditions. But once rule is made under Article 309, that cannot be breached by executive instructions. Then in Gundachar's case, the Mysore High Court, that is my High Court, presently known as Karnataka High Court, it had held that Road Transport Corporation cannot make appointments except after making the regulations. Supreme Court said no. Power to appoint is inherent in the corporation because corporation has to function. It cannot function without employees. And whenever a new corporation is formed, it takes time to make regulations, put in place the regulations made under the Road Transport Corporation. Until then, you cannot say that RTC buses would not fly. Buses have to fly. It has to serve its objectives. The corporation has to function. Therefore, by passing a resolution and making an administrative instruction, corporation can make the appointments. Therefore, what emerges from the law is, in the absence of a statutory rule or a legislative rule, executive instructions can be issued. But as the Supreme Court cautioned in Santram Sharma, where there is no statutory rules, executive instructions can govern the field. And Santram Sharma was a case where there were rules made, but there were gaps. Supreme Court said, to fill the gaps, executive instructions can be issued. Therefore, ultimately, what the Supreme Court said is, executive instructions can supplement the rules, but they cannot supplant the rules. Then the question of filling up the gaps or issuing clarifications. Here a very interesting case arose under granting aid code. Normal judicial view is that granting aid code is a set of administrative instructions which are not enforceable. Therefore, you can make a law by way of code or codal provisions. Their adherence to that would be at the mercy of the government. If the government pleases, it can adhere to it. If the government is not pleased to adhere to it, in my case alone, though it is violative of Article 14, I cannot complain because granting aid code is not a. This was to a large extent blasted out of the field. In one case arising under granting aid code from the state of Karnataka again. Their appointments had been made by a private education institution strictly in accordance with provisions of the granting aid code. The government directed that their appointments is not in order, therefore their services are to be terminated. It was a granting aid institution. The matter reached Supreme Court. Supreme Court said, appointments have been made in accordance with the terms of the grant. That is granting aid code. Now, your case, that is the case of the government, is appointment is contrary to clarification issued by the Director of Collegiate Education or Director of Public Instruction, as the case may be. Supreme Court said two things about power to issue clarifications. First thing is, the parent rule should provide for such clarifications being issued. Kindly mark the difference between Article 162, Article 73 on the one hand, and these lesser legislations on the other. When it comes to Article 162, it has been held to be an inherent power of the executive government to issue instructions in the absence of statutory rules or to fill the gaps in the statutory rules. When it came to granting aid code, Supreme Court said, whether granting aid code provides for issue of such clarifications, that is the first question. Second question is, who can issue the clarification, assuming that there is a power to clarify? Power to clarify, Supreme Court said, vests in the person competent to make the code itself. Since the code is made by the government, director has no power to issue any clarification. This, now see the hierarchy of the sources of law. Basic law is constitution. Then is legislation, that is enactments made like Road Transport Corporation. Third is subordinate legislation or delegated legislation, which has come in the form of rules and regulations. You can use the word rule or regulation depending upon the word used in the parent enact. Stricto sensu, there is not much of a difference. Then the administrative instruction then the clarifications, then circulars. All these are sources of service. And remember, most important source of service law is judge-made law, which I said is with the assistance of the advocates. Now, let us take what is the hierarchy. Hierarchy of these laws have been laid down in Palur Ramakrishnaya. Palur Ramakrishnaya, I was discussing with my colleague just before I appeared before you. Palur Ramakrishnaya did not say anything different, nor it did not say anything innovative. It only summarized what the Supreme Court has been telling from B.N. Nagaraj. Palur Ramakrishnaya, Supreme Court very clearly laid down the hierarchy of the eminence or which will have precedence over the other. First is Constitution, because Article 13 says anything contrary to this part of the Constitution will be void. And law is defined such inclusively to include bylaws, rules, regulations, customs, and usages also. Because those of you who are slightly older, maybe little younger to me also, present day generation would not be knowing this because they have not heard that. There used to be what was called customary bonus in industries, puja bonus, particularly in West Bengal, then festival bonus in some of the states. These were not governed by any settlement or rule or law, but they were customary rights. Then usage is also law under Article 30. Subject to the condition, when usage can be law is, it should not be unlawful. It should be from times for quite some time. Custom has to be of a immemorial vintage. Usage need not be of immemorial vintage, but it must be of reasonably sufficient long period. It must have been. All these are sources of law. But when it comes to which gets precedence over the other, Palur Ramakrishnaya principles are first Constitution, then Parent Act. Parent Act means, let us take Banking Companies Acquisition and Transfer of Undertakings Act, 1969 or 1970 or 1980. Board of Directors of each bank is empowered to lay down regulations, to lay down by regulations terms and conditions of service of its employees. But that section 19, originally did not authorize the boards to make regulations with retrospective effect. So if bank's board makes a regulation with retrospective effect, it will be void as being without power. Second restriction is for the purposes of giving effect to provisions of this act or in consonance with the provisions of this act. Therefore, if any subordinate legislation or delegated legislation, like a regulation, is contrary to the Parent Act, that is the empowering act, then act will prevail and regulations to the extent of being contrary to it will have to go. Therefore, Constituent Assembly, then legislature, then the delegated legislator or delegated legislation. Fourth is executive instructions. It is not only in the government, even in non-governmental public sector also these circulars are there. They are called by different names in different organizations. Ultimately, they are all executive instructions or administrative instructions. Then come the clarifications, office memorandum. This is the broad hierarchy. Article 13 specifically declares any act which is contrary to this part will be void. Therefore, it is the most superior law. When we, as service law practitioners, are shown a rule or are shown an office memorandum, we have to apply these steps, whether it is contrary to the Constitution, whether it is contrary to the parent enactment, whether it is ultra vires the parent enactment, whether it is contrary to any other higher rule, that is, which ranks higher in judicial precedence, and then take a call as to which would prevail. Therefore, friends, there are virtually, I can say, broadly, 5 or 6 sources of service law, and each has its utility, precedence, and limitations. Ultimately, please do not tell anybody that as one of the senior counsels whom I admire and adore, he told me once that, Rajagopal, most of the people feel service law is a lawless law because there is little law and enormous interpretation of it. I said, sir, it is not lawyer's law. It is not lawless law. It is lawyer's law. It is a challenge to the lawyers, and it is the lawyers who make the service. Ultimately, 7th source of service law is you and me. These are the sources of service law. These are the pecking order of various instruments in service law. And then, of course, we deal with various, there is one more aspect of service law, which is applicable to every employee, every wage earner. There again, legislative instruments like Payment of Gratuity Act or Payment of No Bonus Act has gone into, it has gone into dustbin of history. Therefore, it is no longer available to most of the people. And then we have Employee State Insurance, Employees Provident Fund Act. These are all legislative pieces. Of course, in dealing with PF Act and Gratuity Act, one more thing will have to be borne in mind. If anybody under service conditions has higher benefits of these two enactments, employee is entitled to enjoy that higher benefit. But what the Payment of Gratuity Act and EPF Act says is the minimum. Then we have Minimum Wages Act. In fact, till very recently, I was under the impression that Minimum Wages Act has no relevance to service law. It is only relevant to labor law. But recent trend is, you see any government, including the central government, they all claim to be very welfare governments for the common man, they are all the governments of the masses. Giving holiday to Part 14 and Part 3, they are employing contract labor. Therefore, now Contract Labor Regulation Act also will be applicable. Then sometimes the daily wages fixed by the government to those contract laborers is less than the minimum wages. Therefore, Minimum Wages Act also will have to be applied. These are broadly the sources of service law. Now, Mr. Vikas, I think I should close and audience should start.
So I will only say that once you speak, I'm reminded that what we read in the childhood times, Pied Piper of Hamelin, though it had a wronger connotation, but the way you spellbound everyone, you take everyone to the, not to the well, but to the deeper oceans of life, and how to pick up the pearls. That is one aspect, like we did in the previous sessions. You have already shared the knowledge. We will share a few questions from and answers from you. Like all they say that service law is a big ocean. With your vast knowledge, what tip would you like to give to them that how to pick the pearls of wisdom and how to place them in the drafting?
I agree that service law is a very huge subject. And sometimes it depends on the concept of justice which a judge has in his mind. Each judge. I was confronted with the same question as a nuclear physics student when I was doing my MSc in nuclear physics. My professor said, nuclear physics is a very vast subject, and you are going out of this university as a master in nuclear physics. You should be able to tell when you go out. I know, sir, nuclear physics to the extent it is contained in Kaplan. Kaplan was one of the most famous authors of the nuclear physics. Like that, there are different books. I personally adore Services Under the State by Justice Ramajoyce, not the later edition which was edited by Indian Law Institute, but earlier edition, earlier to it. If we read one such textbook, we would be able to tell at least that I know service law to the extent it is discussed in Justice Ramajoyce. Now I think the latest, that is Justice Ramajoyce's book, is this old. You can see. With great difficulty, I am holding the pages together. Subsequent edition has come, which Justice Ramajoyce himself did not like. Now the book that gives you a broad scope and broad understanding of service law is Law Relating to Public Service by Samaraditya Paul, in which all basic concepts have been discussed, and it is used as a reference book by most of the judges. I don't think that even that book is up to date, because every day the norms are changing. Therefore, keep one such book of a learned author. For example, in departmental inquiries, B.R. Gaye is an authority. Now it is in 2 volumes, I think. When I started as a student of law, it was only in 1 volume. Now it has gone into 2 volumes. It will be growing. All that I would like to tell is that pick up the concepts by reading a short book like Justice Ramajoyce or Samaraditya Paul. That will give you an insight as to, when you come across a problem, where to find a solution. That solution may not be in Samaraditya Paul, but Samaraditya Paul helps you to find a solution.
Being a student of nuclear science, you have told what is the rocket science to understand the law in the right way. And so next question would be, like we have taken to the other persons, how to understand or how to build that mindset to interpret in the 2 different ways. Just like in mooting, they are told that for the same proposition, you can think both ways. How to develop that mindset?
That is,
so deliberately, I'm not taking the other questions today because I feel that these students, young lawyers, would like to understand. Like Vikram and myself.
I would put it this way. When a brief comes to you, normal tendency is to look to the strengths of the case. What are the strengths on which I can succeed in this case? I think that is a wrong focus. First priority should be to find out weaknesses of your case. Once you find an answer to those weaknesses, then you can locate the strengths and build on them. Same. Now, this leads to a very critical thinking. If you want to imagine the weaknesses of your case, which is difficult because our kids are, according to the champions, there is no weakness in my child. But by looking to the weaknesses, what would be happening is you would be trying to decipher what the case of the opponent would be. Because the respondent's brief starts after the court admits your case. Unfortunately, we are not in CPC regime. When you go to the High Court or when you go to the Administrative Tribunal, our first opponent will be bench itself. They will start asking, what is your right? Then comes the respondent's counsel. Therefore, first thing, what the respondent's counsel would think to oppose your case. Then you draft your pleading. That is how you can make your case that much more foolproof, and you would be able to understand and assimilate both points of view, and you would be ready beforehand to know the opposite person's case and keep your ammunition ready to demolish it. Therefore, if a respondent comes to you, think as petitioner's counsel. If a petitioner comes to you, initially think as respondent's counsel. That is very essential for you to first formulate your case, then develop your case, then argue the case, so that judgment will be delivered somewhere near your expectation. I don't say somewhat favorable to your client, but somewhere near your expectation, because what we tell the client and what we know as the strength or weakness of the case, sometimes there is a divergence. Just 3 days ago, I had a case under commercial law. By the time top men of the company came, I had prepared a 2-page note as to why their case should be dismissed. The moment they came, I gave copy of that note to the person leading the team on behalf of the commercial enterprise and told him, go through this note and tell me if I have understood your case first. If I have not understood your case, correct me on facts. After so doing, answer me the questions I have posed within. They are happy, they know what is their case. Then to my surprise, the chief executive of that company gave me answers which satisfied my questions slightly above 50%. Then I said, I will try to argue your matter because it is an arguable matter. Don't think as a petitioner, don't think as a respondent who is your client. First, think of the opposite party's case. Then you are through. That is the only way we can analyze a case.
So we can say that we should start developing the art of reverse thinking and then start structuring our arguments.
Yes, it is more or less like reverse auction is there now.
Yes. Now, next question would be, how to funnel the arguments or how to structure the arguments once the case comes?
That is a difficult question to answer because my personal view is quite different from normal thinking. Before you take, for example, in some temples, you have to take laddu and laddu prasad chadanaka. In some cases, in some temples, you have to carry water because you will be Abhisheka Priya Rudra. In some temples, you have to take sari. These are the things which would please that god or goddess. We would have known the law.
And at some places, oil also.
Yes. We should also know the thinking of the judge. I am not casting aspersions on anything. For example, each judge will have his thinking process, which may be different from other judges' thinking process. Therefore, first identify in terms of thought process of the particular judge, which is the argument that is likely to appeal him to most. You might have 10 points to argue. You would have made a note. And these days, making note and going to the court is very easy because you have computers, then you can make corrections and all that. When we started, it was difficult because we have to make handwritten note and take it. Without a note, I have never argued a matter. Even at this age.
Also notes, sir.
Without arguing note. Notes will come before
Lakshmi.
I argue. Because,
combination of Saraswati and Lakshmi.
Yes, it will come. And this is the only profession because where Lakshmi and Saraswati live together. Because if you are strong in your profession, in your concepts, presentation, money will automatically come. Otherwise, general thinking is that Lakshmi and Saraswati, they never live together. No, that is totally inapplicable to profession of law. This is the place where both live together. Books will live with bundles. Books, heaps of books, tons of books will also live with bundles of money. Of course, I only hope that government is not hearing to think that I am having lots of money.
Well, I'll just correct the last part. Government will not think, government knows it. They know that you have pearls of knowledge and the ocean is full of pearls only at your place.
There is one thing. In fact, I have told some of the judges. Yes, judge will ask, your first ground is this. You have raised in the petition. Then I would tell, I am not going to argue that ground. Yet they are the threshold. Go to ground 3. When I drafted the writ petition, so and so was the judge. Therefore, first ground is the ground that would have appealed to him. Now the roster has changed. Third ground is what I would urge before this court. Then one judge asked me, why? I said, when I go to Vishnu Mandir, I cannot make Shivastuti. I will have to recite Vishnu's Namam, then only I will get the thing. Take all grounds in your pleadings. Which ground you would project would depend upon which is the latest judgment which would be still green in the memory of every judge. Whether any point is there in your pleadings which would fit into that judge. Second is, conceptually, which concept of justice is dearest to this judge? Something that happened 35 years ago, I will tell. One judge, very learned, very noble judge of my High Court, he had a view, widows are ill-treated class. It was true. By accidental slip, or I don't know in what context, the appellant's counsel said, "My lord, widow." Then the opposite man had to shout, "My lord, there is no widow in this case at all." See, that is what would be received instinctively by the court. We should try to project. Ultimately, we may lose, we may not win on that point. We may win on a different point. But you should have created an attentive mind in the judge to hear your case. First ground need not always be the best ground, though it is said so. But the first 5 minutes of your submissions, if you cannot impress the court, forget about winning the case after 5 days of arguments. Whether it is final hearing, whether it is preliminary hearing, whether interim order, whatever it is.
So the present substance of your submission, whatever you have stated is that once you go to the court, just remember that old song, "Jo tumko pasand wahi baat karenge." And second is,
you're right. "Jo tumko ho pasand wahi baat karenge." Yes.
You will climb the ladders when you go to the. You have the best of the dices. I will ask Vikram to. We thought that you share so much knowledge. Questions, once we take these entire series, it will continue. Over to you, Vikram.
Thank you very much, Vikas sir. I have no words to say. Extremely erudite and intriguing presentation as usual. And this piece will go on for a few more days. That is the best part of it. So once again, sir, thank you so much on my personal behalf and on behalf of Beyond Law CLC. It was a great presentation, great opportunity for all of us to learn more and more. Thank you, sir. And my special thanks to Ashwini Rajagopal, Madam, and Mr. Jayant, Office of Senior Advocate. I also extend my thanks to Mr. L. Srinivas Babu, former Chairman of the Karnataka State Bar Council, present member, who has logged in.
What's the name?
No, Srinivas sir told that he will not be able to unmute and speak. So once again, thanks to all the participants, and a special thanks to our champion, Mr. Vikas Chatrat, for all his efforts. Thank you so much.
Thank you.
Awesome. Over to you, Ashwin. Sir. Thank you, friends, for having connected with us. It's always a pleasure hearing Mr. Rajagopal, and it's all.
Because, sir, if we could ask Ashwini Madam to share a few words.
I've asked her to unmute.
No, she switched on her video. I think you should give her the option for the second.
Not unmuting herself. Ashwini ma'am, can you come on the screen?
So nothing much to say, sir. Thank you very much.
I think you have the other speaker has to be switched off.
2 gadgets have been switched on, I guess.
That once you have a father who is a larger than life image, how do you learn from him, and how do you come out of that larger than life image?
Yes, sir, you should give her an yes.
Sir, could you please?
Madam, I think 2 gadgets have been switched on,
Yes,
so your
yes,
voice is echoing.
Sorted that out. Sir, could you please repeat the question because of the?
I'm saying that
audio
once you have a father who is known larger than life image for his knowledge, how do you? Because this is like people say that once it is a second generation, it's easy. But how do you maintain your separate niche like what you have done? What lessons you have learned from your father to create your separate niche out of that? Because they say under the
Because, sir, there is a technical glitch at your end. We are not able to hear you.
I don't know what happened. I think there's a
I think what Mr. Vikas is trying to convey is, sir is such a personality with, we cannot explain in words. And having him as a father, so what would you say? And what is the learning curve that you have experienced as a daughter as well as a junior of the senior advocate?
Sir, we specifically make it a point to keep our personal and professional relationships separate. So once we are in office or in court, I am as good or as similar or equal to any other colleague in the office, and there is absolutely no distinction. If we work as a team, and if sir treats us all equally, and the knowledge sharing and the what would I say? The expectations are the same. So there is no distinction, no difference. And it's all a process of learning. So there is nothing special. It's that you do your own work and the guidance is always there.
Mr. P.S. Rajagopal is such an, once he has delivered the entire lecture on Article 14, he keeps in mind that Article 14 is meted out, though it's a private sector, that it's worked out in the right way.
Absolutely, sir. Absolutely.
I will ask sir I will like sir also to pitch in, because it's a rare occasion where people are connected together. Rajagopal sir, how do you maintain that balance? Because this is also a challenge for any good professional when their child comes in the profession. How that within that, they say all under a good tree or a good banyan tree, the normal tree doesn't grow. So how do you create this that the person can create her space like Ashwin? So you will have to unmute yourself.
Now I can say one thing. Equality, practicing equality has been an instrument of faith with me. This I learned as a student and by watching the society. Say I come from a rural background where in a family there used to be 5, 6, 7, 8 brothers. Each one of them is having equal number or little lesser number of children. And the way my grandparents, they would treat everybody equally, it was amazing. If one half of laddu is given to one child, every child will get only one half only. No grain more, no grain less. And if amongst the children, they would share, they would tell, yeah, now you like this item more, therefore you have little more. Equality, the inequality my parents or my grandparents were not creating. It was, sharing was with love, so that the person who is in a greater need would get it. That is how I have been managing. In fact, my first advice to my daughter was not to join my office. But when she persisted, I said, be prepared to face the wrath of my discipline in the office, because because you are my daughter, I will not scold you less, but you may be getting more scoldings than others will get. That is how I have not aroused any expectations in her that she would get a preferred treatment in this office, and I've been able to maintain it by the grace of God, because if I can't practice Article 14, I will have no conviction in arguing for Article 14.
So you have taken that
Constitution. We have to live Constitution. Then only we can become a lawyers arguing on constitutional values. If I am bigamous, I cannot argue for purity in the personal life. Therefore, that is most important, and somehow it has come. I would thank my God for that, because it is very easy to be going into the trap of personal likes and dislikes that we cannot afford to have in our course. Everybody is equal, even amongst the clients.
So reasonable classification reasonable classification and intellectual. I said reasonable classification and intellectual being slightly carved out in the office.
That reasonable classification, it is likely to end up as unreasonable classification. Therefore, in some areas, it is better to maintain wooden equality.
So we end up with a lighter note, and it is always a pleasure hearing, sir. And tomorrow,
Because I think, before we wind up, we should extend our thanks to Honorable Judge who has joined. The name is not visible, so shows just justice. So we would extend our many thanks to the Honorable Judge, whoever has joined.
That's true. And that is the only way we can do justice for the part that is anonymous, but we pay his regards, pay our all regards for his participation. That gives the right impetus or the right catalyst to move forward for the sessions. And that is the way that we have been able to do more than 500 webinars. And tomorrow we have and denials. More specific relevance would be on the civil courts. That is by S.R. Somashekhar. Do stay connected with us tomorrow at 6 p.m.